Yeah, I'm told we couldn't show all the video on that story. Now national health care and Lindsay Lohan's antics. 2012 was a big year for the courts. In January, the Supreme Court ruled that before the government places a GPS tracking device on your vehicle, it has to get a search warrant. And then 4 months later, it ruled that children conceived through in vitro fertilization after the death of a parent are not automatically entitled to survivor benefits. And then, of course, in June, the High Court gave final approval to President Obama's health care law for a look back at the most notable cases of the year and also what the court could look like from here. Doug Burns, a former federal prosecutor and criminal defense attorney, and John Manuelian, a criminal defense attorney as well. Fortunately, I don't need any criminal defense today. Guys, thank you so much. I know that you can also talk a lot about the Supreme Court because people may not realize that these high court cases really influence those who are practicing law day to day. Doug, what do you see as some of the significant rulings? Tell me your thoughts first on the health care mandate.
Well, the health care ruling was very interesting because I've called it right from the beginning sort of a head fake. All the reporters ran out of the building say, it's been struck down, because what happened was in the opinion, Jamie, as you remember, it was struck down on Commerce Clause grounds and on what we lawyers call the Necessary and Proper Clause grounds.
It had to be.
Yeah, and exactly. And then there it was on page 10 or wherever it was that it was being upheld as a tax, which I agree with. But the long and short of it is it's the same analysis that we rendered all year long, which is it's 2,700 pages long. I'm not so sure that anybody really understands it. I asked a good friend of mine who's a practicing physician. I said, could you explain the basics of the healthcare law? He looked at me blankly. So hopefully it will make.
Well, it's like the tax code.
Yeah, exactly.
But the bottom line is, note to law students: you read the last 3 pages of the decision before you read the first 3. But I digress. John, what do you think about the court agreeing to take up 2 gay marriage cases? What could be the impact of that?
Well, the court has a balancing act to do. Obviously, if you're a person of homosexuality and would like your rights, there's an equal protection clause of the Constitution. So the court's actually going to be visiting this and applying a balancing test to what, if any, rights gay people and gay marriages have and apply it accordingly. So it's going to be interesting to see how this court particularly is going to interpret that classification of people. Specifically homosexuals and what they want to do, which is get their full rights as any one of us members of society have. So that's going to be interesting. But going back to the Obama clause, the Obama Health Care Act, I thought that was a particularly interesting ruling from the court. I disagree. I think the 10th Amendment belongs to the states. So, I stand aside from my colleague, Mr. Burns, on that one.
No, and you're entitled to your opinion, certainly. I want to ask you, though, and it's interesting, take a look at those 2 cases and contrast the makeup of the court right now and the fact that in a second Obama term, Doug, President Obama could appoint as many as 2 new justices. It could happen. That could really change the complexion of the court. You probably still have Kennedy as a swing.
Right.
What do you think it'll look like?
Well, of course, it depends who leaves. I mean, Ruth Bader Ginsburg, obviously, everybody is saying will most likely be the next justice to leave the court. If that happens, then ideologically it's a swap in a sense. And then what you were getting at, Jamie, and you're right, is, what about the next seat that becomes vacant? Will there be some type of ideological shift? I mean, I can't resist the editorial that it's unfortunate that people view the court as being somewhat of a political institution in the sense that the justices rule in fairly consistent patterns. But the reality is the cases that get to the Supreme Court are so close and the standards are so wide open that that's why you see those tendencies.
John, do you think that Justice Roberts could make any court makeup work in terms of really interpreting the Constitution in the way that it was meant to by our, the forefathers?
This is what I learned from the Obama case. I learned that the Supreme Court is unpredictable. As we discussed earlier, everybody thought it was going to go one way and went the other. Roberts surprised us all with his decision and which side he went on. So it's really hard to tell. And again, Obama does get the opportunity to pick 1, if not 2 other Supreme Court members. But based on what we saw with the Supreme Court and the Obama Health Care Act, again, we don't know which way the Supreme Court's going to go. The dynamic is different in every case. Facts are very individual and obviously unique in every case. So it's really hard to tell and predict these types of outcomes.
John, what other case struck you this year as being interesting for the court to hear to begin with, and a decision that came out that really was thought-provoking for you as a very experienced attorney?
I thought the Jones case was good, requiring the GPS, the warrants on the GPS cases. Specifically, the U.S. Supreme Court said, look, if you're going to follow somebody, you're going to put a GPS system on their car, you're going to need a search warrant. And as a criminal defense attorney, obviously, I hail that decision because it is an intrusion on your Fourth Amendment rights, specifically the right to privacy. And again, it's a slippery slope. If the U.S. Supreme Court denied that and said they don't need a warrant, then what else could what else could our government do to us as far as our privacy rights are concerned? So I hailed that decision, and I was very happy about the ruling on that one.
You know, Doug, you're a former prosecutor. I was not. I am surprised that you didn't need a search warrant in order to place a GPS device. Why did it make it, Doug, up to the Supreme Court?
Well, I think historically they would put some kind of, when I was in the U.S. Attorney's Office, like a bird dog device, which wasn't GPS per se, but allowed for some tracking. But I think that when it got to the level, and John's right, where they could literally, see on a screen exactly where you were, as he says, I mean, you're looking at sort of a big brother concept. And I think under the Fourth Amendment, the court correctly ruled that you need a search warrant, which in simple English means you've got to establish some kind of level of probable cause that the person is violating some law before you can do that, and I agree with it. Yeah,
it's a good standard.
Yes.
I got to tell you, you came in on Christmas Day. I really appreciate it. It's one of the most interesting legal segments I've ever had the pleasure of doing. Thank you both very much.
Thank you, Jamie.
Thank you.
John.
Merry Christmas.
Bye-bye.
Merry Christmas.